Calling criminal number 14-1-0168, State of Hawaii versus Christopher. Strike that. Calling criminal number 10-1-0262, State of Hawaii versus Brian Murphy for second motion to modify special terms and conditions of probation.
Good morning, Your Honor. Christopher Dunn and Andrew Von Son on behalf of Mr. Murphy, who is present and in custody.
All right. Good morning. Good morning, Mr. Murphy.
Good morning, Your Honor. Tracy Jones, Deputy Prosecuting Attorney, appearing on behalf.
All right. Good morning.
Judge, regarding the argument this morning from the defense perspective, I'll be handling the procedural issue that's been raised by the state, and Mr. Von Son will address the merits.
All right. You may proceed.
Judge, regarding whether the court has jurisdiction to hear this or whether the motion's time barred, I have brought this motion on behalf of Mr. Murphy under HRS 706-625, revocation or modification of probation conditions. I would argue that that type of motion can be entertained by the court at any time during the duration of a person's probation. In fact, I have brought identical motions for early termination of several defendants' probation several years into their probation, well outside of the 90-day limit that the state is trying to impose upon us today, trying to structure this as like a Rule 35 motion to correct the sentence or a motion to reconsider sentence. This is not brought under that rule. Again, this is brought under that HRS statute that I just cited, which indicates that this type of motion can be brought at any time. Regarding the state's argument that the motion somehow violates the plea agreement in this case, nothing that Mr. Murphy's asking for in terms of a modification of his probation is outside the parameters of what the original plea agreement entailed. It's not like I'm asking for Mr. Murphy not to be put on probation or to be precluded from the normal terms and conditions of probation, to which he agreed as part of probation that he would be, as part of the plea agreement, he'd be subject to the terms and conditions of probation. So I'm not asking for a sentence that's outside of the parameters of the original plea agreement. So I would put forward to the court that this motion should go forward on its merits, and that there is no procedural bar or no bar pursuant to the plea agreement that can be carried.
Thank you.
By the merits, I'll turn the floor over to Mr. Von Son.
Mr. Von Son.
Yes, Your Honor. Thank you. You know, when I first wanted to get this into the court as fast as possible, it's always been based upon my concern for Mr. Murphy's health. And I think once you've looked at the record from the jail, you can see that he's had a very rough time of it. For one thing, they can't control his pain because they're not allowed to give him narcotics. And not that we want him to have narcotics. He doesn't want to get back. He didn't want to do narcotics. He wants to go back to his medicine. But they can't control his pain, so they keep giving this stuff called gabapentin. Now, gabapentin is known under another name called Neurontin. And as you can see from Dr. Rogers' report, which is Exhibit A, the patient is having side effects from his medication, a lot of difficulties with mental functioning and emotional lability with taking the Neurontin, basically, and gastrointestinal bleeding. So what's happening is he's had, you wonder, like the last time he was here, I think he burst into tears. That's what happens when you do this gabapentin. And Dr. Rogers said, Dr. Rogers said it in his notes. He said, don't do this stuff. They've been giving it to him from the very beginning of when he's been in jail up to now. So basically, I started this out just thinking, well, I want to appeal to the judge's reason and compassion, but I really sincerely believe we have an Eighth Amendment issue, a cruel and unusual punishment issue here, Your Honor. Because what's basically happened is if you deny...
Excuse me. Stop.
Yeah.
You cannot do that. That's not respectful to anyone. Don't do that again. I'll have to have you removed from the courtroom. That is not how business is conducted in this courtroom. And if you were in Mr. Murphy's seat, or if you were on the other side of it, you wouldn't want anyone to treat you like that. Don't do that again.
Yeah, Your Honor, to catch up with my mind here. So basically, I sincerely believe there's an issue here as to cruel and unusual punishment. And so, like, I'll speak more about it, but basically, if you deny the motion, what you'll be doing, in effect, is sentencing Mr. Murphy to continue to get these drugs that actually confuse his mind, create emotional lability. In other words, he's crying spells, you know, and that's punishment in itself. And then you're sentencing him to not have the drugs he needs and to deal with his pain. You know, they're trying to, basically what he has done, he's cut back on the gabapentin as much as he can so that it does, because he wants to have his mind, you know. What do I want, my mind or the pain? And so he's made this choice. I want my mind, but he takes a little of that gabapentin because he's in so much pain, you know. So it's like, that's what you'd be sentencing to, in effect, if you deny the motion. Again, going back to Dr. Rogers, you know, it speaks for itself. He also, in Dr. Rogers' report, speaks to the pain, lumbar stenosis with left L5 radiculopathy. I mean, the man's in pain. He's been in pain for a long time. The VA, as you can see from the medical records, the VA has prescribed him. They prescribed him oxycodone for his pain. They've prescribed him medicine for his PTSD, and those are VA. That's doctors seeing him. The doctors saw him, and they did that. Now, what Mr. Murphy has done is he's found a way to avoid taking these narcotics and all these drugs, and he takes 1 or 2 tablets a day or capsules a day. He doesn't smoke marijuana. He takes this medicine once or twice a day, and that's been able to cover all this stuff, you know. And so, additionally, you know, if you keep him in jail, he doesn't get the PTSD treatment. Dr. Lenz, Dr. Lenz is here if you need to hear from him, but I think his report to you and his assessment to you and his proposed program to you is quite complete. You know, he says in there basically that his concern is Mr. Murphy's his debilitation has continued. You know, he keeps continuing. He's getting worse and worse and worse. He's talking on the phone, and, you know, his concern for Mr. Murphy. And so, you know, he doesn't need some kind of a drug rehab program, Your Honor. You know, I know you mentioned when in our conversations that he had done heroin earlier in his life. For people who think about this stuff a lot, which I do, somebody goes from heroin to marijuana to cannabis, that's a model. You know, that's a model you want to follow. I know, and you can't even give him, by the way, you can't even give him the oxycodone if you wanted to for his pain, for jail, because apparently it just can't be in there. No narcotics in jail, even if a judge orders it. So, not that that's necessarily a good idea to get him hooked on oxycodone, you know, because that's the closest thing to heroin. The reason we have a heroin epidemic now is because damn oxycodone, and then oxycodone became more expensive than heroin, so people switched to heroin. I mean, it started with oxycodone. It's a dangerous drug. So anyway, Mr. Murphy's found a way to avoid all that. You can see from Mr. Maroney's paperwork on the assessment, substance abuse assessment, that you know, he doesn't really have a problem. He's got this need for marijuana, or for cannabis. I'll call it cannabis. Marijuana seems to have this tinge to it. But he's got this need for cannabis, but that's because it deals with all his problems. It deals with his PTSD, or it helps him with his PTSD, helps him with his pain, you know, and he was very functioning, as you saw from the school records. He went back to school. I think the one really good thing that came out of this is that he went back to school. You know, that, and you saw his grades. He did quite well. Dean's List, he's got a 3.7, something like that. And so, you know, again, if you don't release him, he won't be able to go back to school. He wants to start in June to do summer school. If you don't release him, he won't be able to get the treatment he needs from Dr. Lenz. And Dr. Lenz, again, is here. And Dr. Lenz is somebody Dr. Lenz took over from Dr. Sword. So Dr. Lenz is the PTSD guy on the island. He knows his stuff. And Mr. Murphy has PTSD. I mean, you can see from the prescriptions given by the VA that they prescribe. I can't remember how to say it, misoprostol or something like that for PTSD. So he's got something for PTSD, got something for back pain. You know, those things are right there. So it's acknowledged that he has these problems. Dr. Lenz, you know, acknowledges he has these problems. Dr. Lenz has a program for him. You know, and then, you know, on top of it, he's in custody now. He's in jail now for a crime where there are no victims. It's a victimless crime, and what he was doing was they had this patients without time, and they were getting medical marijuana for people who really needed it. In fact, I believe it's in the record because this has been going on for so long. You saw he got commendation from the state of Hawaii, the legislature there back in 2009. They thanked him, for fulfilling this need. And now, not only that, but they're finally catching up. It's like government always seems to be catching up with, people seem to lead and the government catches up, maybe, hopefully. But now they want to implement exactly what he was doing. And by the way, he wasn't charging people 400 an ounce, everybody 400 an ounce, which I believe somebody put that was put in your head, the original sentencing. Some people paid nothing for this stuff. If they couldn't afford it, he'd get it to them. It was a sliding scale. So it wasn't a profit-making situation. It was really a situation based upon heart and soul. He really cares fervently about this, and I believe you see it that way too. It's not like he doesn't care, or he was in it for the money. Number B, the Dr. Charles Webb. He's seen Mr. Murphy. I believe his health would be best preserved if he were allowed to use his medical cannabis in place of his several current medications. As noted by Dr. Thomas Rogers, who recently examined Mr. Murphy on March 4th. And again, this is March 4th. 2 months ago, almost 2 months ago, Dr. Rogers says, hey, this Neurontin is confusing him and is causing emotional lability. And as you know, emotional lability, what that means is your emotions go, whoa, all over the map. Suddenly you're crying. Why is he crying? No reason. He just is, emotional lability and also with ibuprofen. So ibuprofen, they were giving him ibuprofen for pain, and that's pretty strong stuff. The problem with that is it burned a hole in his stomach. Either that or his intestine. He has blood. He had blood in his feces. So now they want to give him a colonoscopy, and so he's refused to get it from the jail, hoping he can get it from real doctors. Nobody wants to get their treatment from halava. Again, Mr. Murphy explained difficult mental functionings. Blah, blah. These medications can be replaced by a much safer alternative of medical cannabis, which is legal, as you know. The state is kind of catching up with it, but that's the deal. Again, Dr. Lenz, I'm highly concerned about his psychological well-being. Dr. Lenz spoke with another psychologist and a social worker, and they're concerned for Mr. Murphy's well-being. Mr. Murphy exhibits numerous and intense psychological signs and symptoms. He experiences highly labile moods with easy tearfulness. He describes numerous fears, and these were conversations the doctor had with him on the phone. He describes periods of confusion, and I note that in conversation his changes of topic are sudden, frequent, and sometimes difficult to understand. He describes periods of deep fatigue that appear to be caused by depressed mood, intense chronic pain, and demoralization. During our last conversation, he expressed fear that he is so upset and confused at this time that he no longer knows how to live on the outside. He said he feels a great deal of need for guidance in reattaching to and reinvesting in everyday life. So he can get the help he needs if you release him. If you don't release him, he's stuck in jail. They're giving him medications that exacerbate his PTSD. They literally exacerbate his PTSD. They don't do him any good. They mess with his mind. He doesn't get the pain meds that he really needs, and he was covering with the medical marijuana. Again, so you're sentencing him to this, and I really, when I first was looking at it, I was just trying to gain your compassion, but I really believe there's an Eighth Amendment issue here, Your Honor, a cruel and unusual punishment. I sincerely do, and I really hope you take that as not just some kind of play on my part, but I really feel strongly about it because I talk to him a lot too, and I'm concerned for the guy, Sure. And again, he was doing something that no victims, people, a lot of people saw him as a good Samaritan, and so here he stands. Let me just see if I have anything further here, Your Honor. Oh yeah, he had an. Yes, Mr. Mr. Dunn suggests I talk more about the plan. The plan is Dr. Lenz has written out the plan, Your Honor. And I assumed you had read it, but we'll go into it. For at least 2 weeks following the beginning of therapy, I propose to have 3 sessions with the client per week. The exact scheduling will be worked out to dovetail with Mr. Murphy's other court-mandated and court-approved responsibilities. I have a fair amount of flexibility in my schedule at this time and intend to take advantage of that flexibility to meet the needs of the client. After Mr. Murphy's conditions improve, I propose to reduce sessions frequently. Therapeutic methods utilized, time perspective therapy. This therapy was developed by his predecessor, Dr. Richard Sword, for use in treatment of post-traumatic stress disorder. At this time, I see Mr. Murphy's primary need for therapy is due to chronic but formally adequately managed PTSD and his present need to readjust to life outside prison and to live with major health issues and with PTSD that has been greatly exacerbated by his incarceration. He's a veteran, so this can be paid for by the Veterans Association, or the VA. Dr. Lenz, again, Dr. Lenz is here. He knows what he's doing. He does PTSD. That's what he does. There's a lot of vets that go to him. He'll be dealing with Mr. Murphy's apparent condition: depression, anger, anxiety, sleep and somatic symptoms. Again, the report from the SAE report doesn't really talk about it. It quite clearly shows that basically, yeah, he uses cannabis to deal with his pain and his symptoms, but beyond that, he doesn't really have a substance abuse need. He wants to get back to school. As I said, he did very well in school, so it's part of the plan. His letter to you, which I have neglected to refer to, and by the way, writing a letter was difficult for him because of the drugs he's taken. So this may not have everything maybe you had hoped it had in it, but it was really hard for him to get it together because, again, I don't even know if they can do this in Guantanamo. Can they give people drugs to confuse them and create emotional lability? I don't know, but you certainly can't do it here in the United States, not under the, not compassionately, nor under the 8th Amendment to the Constitution. But in any event, Mr. Murphy's plan is that he wants to go back to school. He wants to get his degree so that he can become actually someone who can help people who are having problems with their addiction. And there's nothing like, the people who you have in drug court, who help you in drug court, the drug court people, the ones who know what they're doing, most are people who have been there, they've been there. And so they know when people are BSing them, they know how to deal with that stuff. So he's perfect for this, and he wants to go back to school. He's excited about it. School starts in June. He needs time to get himself together after this period of time, so he can be ready to go to school. And again, if you don't release him now, it's like you're sentencing him to just more torture. Let's see if I got it all. Well, I would submit it, Your Honor. I would submit it under compassion, reason, and 8th Amendment cruel and unusual punishment. And thank you.
All right. Thank you very much. Oh, I'm sorry. I thought you were finished.
Yeah, I'm not sure if you want to hear from Mr. Murphy or Dr. Lenz, if that's necessary for you to...
Not at this moment.
Okay.
Yeah. Thank you.
Thank you.
Ms. Jones.
Your Honor, I'd just briefly like to respond to the victimless crime allegation. It's the government's position that illegal narcotics on a global scale fuel terrorism and organized crime. On a national scale, they fuel organized crime, elements of terrorism, and widespread addiction. And on a local level, it steals mothers, fathers, and children from stable family homes and delivers them into the depths of drug addiction. So it's far from a victimless crime. The trade of illegal narcotics leaves in its wake a path of many tens of thousands of victims in many different levels of how the drug trade touches their lives. So we have pretty much the opposite opinion of the victimless crime argument presented by the defense. In regards to what's before the court today on this motion, it is a motion to reduce sentence. It seems like, because the state's been clear, and I believe the court also has been asking for this information from a medical doctor to show a medical need that this defendant be released from incarceration, that he was sentenced to by this court as a benefit of a plea agreement for serious crimes. He was facing 10 years in prison. We made a plea agreement for probation. We argued, and they argued for less. The court gave him a year. Now he doesn't want to serve it, and is asking you basically to reduce the sentence that he got the benefit of by striking the plea agreement with the state, without giving the court what it really needs, which is testimony from a doctor that incarceration for him is detrimental and that he is not physically able to endure it. That hasn't happened. And until that happens, it's the state's position that the court should not modify its sentence. We'll ask that the court consider this a motion to reconsider and not hear it. If the court does grant jurisdiction over this motion, because the court does have jurisdiction over this case until the end of this defendant's probation, that you require the defense to come forward and bring before you credible, real information that will be given to you by a doctor, a medical doctor who understands the challenges that this defendant is claiming and the requirements of the court for his incarceration. There's doctors in the jail. There are specialized medical units within the Department of Public Safety that have offered him treatment that he's refused. We agreed to even allow him to leave his incarceration for the day to go and have an examination at the VA on Oahu. The reports for that still have not been shared with us, and that was agreed by the state to allow him to have access to the doctors that could give the court the information to really consider his motion. And until that happens, we'd object to the court modifying his sentence. Thank you.
All right.
Just quickly, Your Honor.
Yes.
First of all, cannabis is not a narcotic. I mean, I agree. Narcotics are bad. You know, it's like oxycodone. That's bad. You know, heroin. That's bad. It's ruining. It's detrimental to our country. You know, and two is we do have on the record here. We don't. The record is clear from the jail records. The jail records show the kind of situation, the kind of what's going on with him. I don't think we need a doctor to, just reiterate the jail records. Additionally, Your Honor, in terms of the VA, apparently that won't be ready for like 90 days. So, that, as far as we're concerned, is way beyond. That means if we were waiting for that, it means he's missing school. That means he's got 3 more months of torture. So that's my response to that, Your Honor. I know Mr. Dunn is available with respect to the jurisdictional arguments.
The only thing I'd add is that regarding his most recent medical visit at the VA, the processing of those reports takes several months, and that's related to his ongoing disability and just documenting through that physical his continued disability.
Thank you. All right. Before the court today is defendant's second motion to modify special terms and conditions of probation, and supported by various exhibits, and of course opposed by the state of Hawaii. First of all, with respect to the question of jurisdiction, the court will find and determine that it does have jurisdiction over this matter, such that it can entertain this motion. Second, as to the substance of the motion, that is the request to have him relieved of the obligation of serving further jail time. What the court is going to do is, I'm going to attempt with the parties, and unless there's an objection from the defense, with those that might be knowledgeable with respect to his issues, who may not be directly involved in the process, but at any rate, I'm going to attempt to schedule a staffing of the case, and I'm going to conduct a further hearing in this matter on May 7th, 2015, on the 8:30 calendar. The staffing, if there's, can be informal, or if the parties desire, it can be formal and on the record. But at any rate, the court wants to gather more information. I'd like to have probation present and perhaps some other resources available. And we'll work on scheduling that. That staffing will not occur on Thursday. Thursday, May 7th, will be the further hearing on the motion. So, and Mr. Murphy's ordered to appear on that date and time for that hearing, the May 7th hearing. So the court will be in touch with all of you, and I'll conduct that special staffing. And as I say, if you want it on the record, that's fine. Although typically the staffings are not on the record. All right. Thank you all very much.
What time is that on May 7th?
May 7th, 8:30. 8:30 calendar. Yeah.
Criminal number 14.